Blackburn Bobbin Ltd vs TW Allen Ltd 1918. In the case of Blackburn Bobbin Ltd vs TW Allen Ltd 1918, there was a contract for the sale of 70 standards of Finland timber to be delivered to the plaintiffs free on a rail. Herewith, it should be noted that the contract contained no provision regarding the war, force majeure or suspension. In the process of delivery, the seller followed the usual practice established prior to the outbreak of war. Namely, the seller loaded timber in Finland and prepared it for shipment to England. Although, the shipment of goods became impossible due to the outbreak of war. So, the buyer could not obtain any Finland timber. As a result, the buyer brought an action, claiming damages from the seller for failure to deliver timber. The buyer's claim succeeded before the first instance court as the judge saw no reason to consider the contract frustrated by the outbreak of war. Whether there was the frustration of the contract due to the outbreak of war. Whether the seller was liable for the failure to deliver timber. The Court of Appeal affirmed the lower court's decision and held that the contract had not been frustrated due to the outbreak of war. While it is true that the outbreak of war changed the situation, but the main factor in the present case was the failure of one source of supply. The Court of Appeal established that such a failure is insufficient to invoke frustration of the contract. So, in these circumstances, the contract was not frustrated and the seller was liable in damages for the non-delivery of the timber.